Okay, so this video is going to be a business lawyer's practical takeaways on the CTA. I'm going to give you just a quick overview of what it is and some takeaways. I'll give you some information about it too, but it is not going to be an exhaustive list of the requirements, a review of the regulation. All of that information is available online. Also, you really do need to talk to your own attorney about your own reporting requirements, what needs to be reported, whose information you should be reporting. As we're going to go over in a couple minutes here, there's going to be some information that you're going to potentially have to ask from some people who may not want to give it to you. And the type of information is traditionally viewed as pretty private. And so the challenges you're going to face as a business owner with the CTA is most likely going to come from internally. There's probably going to be some people who don't want to give this information to you for reporting purposes, and you're going to have to ask for it, and you're going to have to insist on getting it if it applies to you. So that being the case, all the details that support your reasons for asking for it and your reasons for reporting it, I really recommend that you could talk to your own lawyer about whether you really fit into these categories and whether you need to report information from certain people. Okay, but I will give you quickly just kind of an overview of my impressions of the statute, the regulation, what it's for, kind of what it's about. Let's do that now. Just remember, don't take this as legal advice for you. If you are one of my clients through a written engagement letter with me, obviously you can contact me. We can go through it together. Obviously, if you're not one of my clients, contact your own lawyer and get that done. Okay. So the first thing to know is what is this thing? Okay, the Corporate Transparency Act was something that Congress passed in 2021, and it went into effect January 1st, 2024. It's something used by the Department of Treasury's Financial Crimes Enforcement Network. So you're going to hear me talk about FinCEN. That's what that is. And there's a lot of penalties that apply for failing to report the beneficial owner information, BOI report, to FinCEN on a timely basis. Okay. And so why do we have this? Why all of a sudden did this go into effect? The United States is just one of many countries that are doing this, and it's a way in which to prevent money laundering. I believe it's aimed at deterring crime, illegal activities, people hiding who's involved in businesses. Obviously, with things the way they are around the world, that's become even more relevant today than in years past. And so this is the United States version of what many countries have in place already. And now we have it. So let's talk about, what has to be reported, generally speaking, who has to report, and we'll go from there, okay? So the categories of people that have to report information are what you would get to after determining whether your company is even one that has to report, okay? Your company will have to report unless it fits into, I think it's like 23 exemptions. Now that seems like a lot, but really, if you're a small business in the U.S., there's a good chance you don't fit into one of these exemptions. I'll give you some examples of the exemptions in a minute here, but like, it's a lot of the exemptions are tailored to be around companies that are already on the federal government's radar in some other way, right? So it might be like financial institutions. They're already heavily regulated, so they know who they are. Licensed, securities brokers or public accounting firms, publicly traded companies, large operating businesses that have, I think it's like 20 or more employees and 5 million of gross receipts. But at the end of the day, those numbers have to be calculated in a very specific way under the regulation. So you'd want to make sure that you really do fit into an exemption before you rely on that. So definitely, if you think you're exempt, you need to get yourself double checked before you make that decision, because like I said, there are penalties for not reporting. We'll get to those in a few minutes here. So in addition to reporting, initially, we'll talk about the deadlines for that here in a second. I will tell you that. You have to report changes. So like in the M&A context, I do a lot of buying and selling businesses for people. The changes of ownership, and as we'll talk about here in a few minutes, it's not just the changes of equity, like ownership of stock. It's actually also who's in control of the business. Those changes are going to trigger update reports that have to be made within 30 days of the changes to FinCEN. So, all right. So when do these reports have to be made? There's basically some different rules in play right now because of it just being a new law. If your company existed prior to January 1st, 2024, and you fit into the categories of a company that has to report, and typically that's going to be a company that was formed somehow by filing something with the Secretary of State. So like a revocable trust for like an estate planning purpose probably doesn't fit into that. You can form those without, filing anything with the state. A de facto general partnership that doesn't have any formation documents anywhere probably doesn't fit. Again, double check all of these with your own attorney. But those are some examples of who wouldn't have to report. But if you're an LLC or an LP or a corporation or anything like that, you are formed by filing something with the Secretary of State of a state. So you're going to have to report. If you are one of those entities and you don't fit into an exemption, then you have, again, if you're prior to January 2024, you have the year to report. So January 1st, 2025 is your deadline. So you have a lot of time, right? I'm making this video in February, early February 2024. So you got another, 10 months or so to get your stuff in order. But I would start. You'll see here in the video why here in a couple minutes. It might take you some time to get the information you need. Now, if you were formed after January 1st, 2024, so like I just formed a couple new LLCs last week for a client, and I'm going to have to report his information on a BOI report to FinCEN within 90 days because he was formed during 2024. So within 90 days of his formation. There's even some rules about how the 90 days starts to run. I'm not going to get into all that right here, but it's about 90 days, okay? If you are formed after January 1st, 2025, so if you're watching this video over a year from now, you only have 30 days. It was originally 30 days for everybody, and then they extended it to 90 days to get started. That's why there's a difference for 2024, okay? Those are the general deadlines, and of course 30 days for any changes to reported information, all right? Now, I'm going to go through right now some of just my observations about this law and some things that struck me or things I think that business owners might want to know, okay? Again, this is not a comprehensive review. Where does this information go? I think that's going to be something people really want to know. My understanding is that it's going to be only disclosed by FinCEN to people like government agencies, financial institutions, etc., following appropriate protocols. Okay, take that for what it's worth. Bottom line is this information is going to go somewhere into some database, some government database somewhere. It will be out there, but it's not like a searchable public record the way that like any one of us right now could go online and search the Texas Secretary of State's office for any business and get the owner's information, right? It's not like that. But the information will be out there, accessible by some of the types of people that I just mentioned. That may end up being an issue for you as you start to gather this information from people who don't want their information out there at all. So we'll get there in a minute here as to who those folks are and the kind of information you have to ask them for. That's going to be a little bit of a burden for you as a business owner in collecting and securing that information and complying with state privacy laws in how you collect it and secure it. So, like I said, you're a reporting company most likely. If you had to, file something to get yourself started, or somebody filed to get you started. Some of the exemptions. Let me give you some examples of the 23 exemptions. Publicly traded companies, SEC registered investment advisors, venture capital fund advisors, insurance companies and insurance producers, public accounting firms, tax exempt entities like nonprofits, entities that assist tax exempt entities. I don't know quite what that means yet, but we'll find out. And of course, subsidiaries that are wholly owned by the exempt entities. So there are exemptions, but like I said, if I were you, if you're trying to rely on an exemption, I would go get some legal advice before you do that because of the penalties. We'll talk about that again in a minute. If you go in or out of exemption status, that has to be reported. So if you were previously exempt, you're not exempt anymore. You don't get to just not report within 30 days. You got to report that. If you were previously exempt or non-exempt and switch, you have to report that. So let's talk about the information that's to be reported. The information about the reporting company is probably not a huge surprise to you. It's going to be its full legal name, any trade names, and that's not just DBAs, but any names under which it does business, which, you know, in the most cases you would have filed a DBA, but some people don't. You should. The complete current street address, so not just a PO box. You know, and there's some other stuff, the state of formation, tax ID number, okay. But the beneficial owner piece of this is a little more controversial, because it's not just, well, it's two becauses. One, because of who it is, and two, because of what information has to get reported. It is not just 25% ownership that qualifies you as a beneficial owner. Yes, that's one of the categories, but it's an or, okay? It's 25% or more, and let's stop there for a second. It's not just common stock. Okay, we're talking about any type of ownership interest as is defined in the regulation, and that is extremely expansive. It's convertible instruments. It could be stock options. It could be profits interests. It could be all kinds of things that are not just stock. So again, got to look at that to see if you have if a person has 25% or more ownership interest, or exercises substantial control over the reporting company. What does that mean? Now, you would think that there was a very narrowly defined way of determining that. There is not. I'm going to give you some examples, but one of those bullets, one of the things in the regulation is a little bit broad. So an individual has exercising substantial control over a reporting company if they serve as a senior officer of the reporting company, and that means like the president, the CFO, the general counsel, the CEO, the COO, regardless of title, however, but if they're performing a similar function to those types of roles, okay? If they have the authority to appoint or remove a senior officer of the business, or a majority control over the board, right? So like I get involved in some acquisitions and some different deals where an investor comes in and wants to have effective veto rights or rights of refusal on, you know, who sits on the board and all these things. They may end up, even if they only have a small stake of ownership, having substantial control. If they direct, determine, or have substantial influence over important decisions made by the reporting company. These are ors, by the way. These are not ands. So if there's someone who isn't a CEO, not an officer, doesn't have the ability to appoint people on the board, but despite all of that, they can direct, determine, or have substantial influence over important decisions made by the reporting company. Substantial influence, that's the word used, over important decisions. These are not things that are defined in great detail, okay? And here's the last one. Has any other form of substantial control over the reporting company, okay? So I've been in situations, I'm sure many of you have been in situations before where, you know, there's somebody who's really in charge. Like everybody knows, okay, yeah, this person has ownership, this person's on the board, this person's an officer, but somehow, some way, through some contract or some right that somebody has, there's some influence being exerted. You're gonna have to figure out how that is and who that person is, who those people are, because they might very well be in substantial control and have to be reported as beneficial owners. And you're gonna have to get some very private information from them. I will get that to you here in a second, what that is, okay? Again, ownership interest, if you're relying just on the 25% equity part, you gotta understand it's not just stock, okay? It's anything similar to stock that confers any kind of voting power or voting rights, any kind of similar instrument, a pre-organization certificate, a subscription, a transferable share of a voting trust certificate, okay? Some other examples are a warrant or a right to purchase a share, a put, a call, a straddle, an option that gives you the privilege of buying above the 25% threshold or at that threshold. Any other instrument, contract, arrangement, understanding, relationship, or mechanism used to establish ownership. Very broad here, okay? So think about things like profits interest. Think about all those types of things. Now, there are some guidelines for how you calculate that 25%. I'm not going to go into those here. And keep this in mind. Even though I said earlier that like a revocable trust for estate planning probably isn't going to be a reporting company, if there's a trust that is in one of those positions, so like if there's a trust that is a 25% owner of a business and their business is a reporting company, the trustee of that trust, the actual human being, is going to have to be reported. And the information is going to have to include what I'm about to tell you, okay? Now, there are some exclusions from beneficial owner status. Minors are excluded. Somebody acting as a nominee or an intermediary, custodian, or agent on behalf of someone else. So I imagine that might be someone like, possibly acting under like a power of attorney when somebody's in the hospital. Certain employees of a reporting company, if they're acting solely in their role as employees who are not senior officers and whose substantial control or economic benefit derives solely from their employment status, okay? So that's a good exemption because that will keep you from having to gather every one of your employees' information, but it's not broad enough to carve a bunch of, all of them out. Heirs, so people that are standing in line to eventually own something, they're not reported. And then certain creditors of a reporting company who otherwise might meet the definition of beneficial owner solely through a loan covenant or something like that. But I would definitely, with some of these exemptions, again, talk to your lawyer about that. Now, before I get to the information that has to be reported about these folks, because that's one of the controversial things I think you're going to want to pay attention to, there's another category of people that have to be reported, and that's company applicants. And that's people like me, my paralegal. These are people that form businesses for people, right? I think that the government wants to know who's involved in forming businesses, and I understand that's part of this protective regime. So the cool thing is people like me are going to go out and get what's called a FinCEN identifier. I've already got mine. My paralegal's got hers. And so if people ask us for our information, if we're doing BOI reporting for our clients, which we're going to be doing obviously a lot of after we form entities for them, we can just put our FinCEN identifier, and the government has that identifier and knows who we are. You can go out and get yours, I believe, as well. There's a process. Go to the FinCEN website. You'll see how to do that. And that way, if you're the kind of person who's often reporting your information, I think you can just put that FinCEN identifier as long as that information's updated, and you'll be able to not have to provide all of your private information to every single person who's asking you for it to be reported. Now, what kind of information gets reported on beneficial owners? And remember, beneficial owners is not just 25% or more equity. It's also people that had that substantial control, okay? So if anyone fits in any of those categories, you're going to have to get from them and provide in your FinCEN BOI report their full legal name, no big deal, date of birth, okay, their complete residential street address, no PO boxes here, and no business addresses. This is residential, okay, specifically. So, I guess if it's a home-based business, it's a residential street address. But for the most part, we're talking about like the CEO's home address. It's going to be reported. And then here's a couple more. The unique identifying number from a non-expired official document like a U.S. passport or driver's license, and a photograph of that document. That information has to be collected by the business from those people and reported. The reporting process is on the FinCEN website. They don't charge a fee for it. But if I were you, I'd be very careful about making sure you do this properly. I would go out and make sure that you talk to your attorney about what information's got to be reported there. Probably worth having somebody who knows what they're doing create the report and submit it for you. But you can do it for free. It is public accessible. Company applicants like me, obviously, it's a lot of that same information, but thankfully people like company applicants can just put their business, their law firm address. But again, you're going to probably get a FinCEN identifier number from them. And at the end of the day, here's the issue I think you're going to have, okay? Issues. You're going to have to be asking some people who don't like giving their information out about their private details, their residential street address, their driver's license, their date of birth. And there are a lot of people out there who do not like to report this kind of information to anyone. They don't like anybody having it. And you're going to have to get it from them, and you're going to have to demonstrate for them that it's secure, that you're only using it for this purpose, depending on what state you're in, and depending on whether this person is in the EU who's giving you this data, like maybe you have a foreign investor or whatever. You're going to have to, at the end of the day, comply with the state privacy law that might apply to you gathering this information. So what kind of notice are you giving before you collect it, right? There's a lot of these states that require now a notice of, at the point of collection, of here's what I'm going to do with this information, the limits of it, here's how long I'm going to keep it. At the end of the day, you can ask for it back, that you have a right to deletion, all those things that some of these states require now, and many states do, you're going to have to be thinking about. Now, you're also going to have to be thinking about security. Where is this information being uploaded to? How are you getting it from these people? Are you giving them a secure upload link, I hope? Are you making sure it's encrypted when it's at a state of rest, wherever you're keeping it. Are you keeping it? How long are you keeping it? As far as I know, the CTA doesn't require a particular record keeping once the report is made, but you really need to be thinking about what's your risk in, where are you keeping this information to be able to prove what you submitted, where are you keeping it on file, and all that. Or are you, like data minimization principles would say you should only keep things for the minimal amount of time that you need to, so that if there is a breach of your cyber security, the information is not just sitting there for someone to get when it didn't need to be sitting there. So you need to be thinking about all that. Now, what I would do is definitely consider having somebody at your company be like a champion of this process. Somebody centralized who, and we'll talk in a minute here about some of the things you might consider having that person in charge of. But, bottom line is you're going to have to comply with a lot of other things, not just the CTA, other things meaning cybersecurity, data privacy principles and laws in complying with the CTA. Before we get into some of the practical implications for you internally, I do want to talk about, I want to make sure you understand there are penalties for violating the CTA. And these penalties are not just for, the company. Let me talk about this. So the CTA has criminal and civil penalties for violations, including a fine of up to $10,000 and imprisonment for up to 2 years for any person who willfully provides or attempts to provide false or fraudulent BOI information or willfully fails to report a complete or updated BOI to FinCEN. The penalties also can apply to reporting companies and individuals who cause a reporting company not to report, or are senior officers of a reporting company at the time of its failure to fulfill its obligation. So if you're a senior officer of a company and the company fails to fulfill its obligation, this is saying that those senior officers could be up for penalties here, criminal and civil, and failing to accurately report or update. And then the CTA sets out additional penalties imposed on people knowingly disclosing or using BOI reported to FinCEN in an unauthorized manner. So if people are really wary to give you this information, they're like, where is it going to go? Who's going to have access to it? Like I said, it's supposed to be just the government, financial institutions. You can point them to the reg on that. But you can also tell them there is a penalty that Congress included here for people that maybe from the inside, end up abusing their access and using things inappropriately. So if that helps. Now, to prepare for compliance, designate somebody. Designate somebody who's going to be in charge of getting this information and communicating with these people about why they need to provide this information and how to get it from them in a secure manner that complies with privacy statutes, right? You want to make sure that your entity records are up to date. There's a lot of people who don't keep their governance housekeeping in good order. I typically see that when someone's preparing to sell their business. And one of the things that we typically do is come in and help them kind of get things sorted out. Do that. You're going to have to do that now. You really need to know who all these, you're going to have to make a list, who's in these positions and who has ownership and what kind of ownership and, convertible instruments and all that kind of stuff. You're going to have to just do an inventory and your lawyer can obviously help you do that. And then you're going to have to go out and get the information from all those people that you've decided need to be reported. And again, that's going to be a process. Now, if you think about this, if you have a business with an LLC agreement or other types of governing documents or any kind of constituent document like a shareholder agreement or something like that, you're going to really have to think about amending not just new ones, but going back to the old ones, voting effectively to change things. So there's a new requirement, if your governance allows for this, that if you want to be a member of this company, if you want to be a shareholder in this corporation, you have to comply with these requirements, and you agree as a condition of your ownership that you will, right? So bylaws, LLC agreements, all those things, think about baking this in there. Think about in the M&A context, who's responsible for making these reports so that it's very clear in any type of merger acquisition situation that the new beneficial owner information report is going to be filed. And think about when that has to be done, who's going to do it. And of course, make sure that you're really considering, the security of everything. I think that's really key. For me, I do a lot of data privacy work, and I really think that's going to be important. So I hope this introductory type of overview of the CTA and its implications has been helpful for you. You know, if it has, please subscribe to my channel. I haven't done a lot of videos in the past. I started to do a couple and I played with it, and the editing was just, you know, kind of onerous for me, so I stopped. But I've decided that when things like this come up, just as a way to describe my impressions of it, I'm going to probably be posting videos more often in 2024. And if you'd like to be on the receiving end of that, go ahead and subscribe and check out my channel in the future. And appreciate you watching. Thanks.